Peace and blessings. Keep up the lessons. This is, Crypto B-Boy. I'm back in effect with the second part. I'm going to try to give you a little bit more of John Denton and Jeremy Kaufman discussing this issue as I did in the first one. And then I'm going to go with our guy, Jeremy Hogan, the lawyer there, and let him do some talk on what he has to speak on in relation to this craziness going on with the SEC, underhandedness, and so forth, which that we have to be mindful about. We really have to be mindful. We have to put our prayers up. We got to ask to hopefully get through this, because these people are wicked in their actions and trying to make the maneuvers. And they're not just wicked by themselves. Of course, we know the powers that be are the ones behind them, pushing them to do what they're doing and using them as their pawns and tools. But that's all a part of the plan. So, we can go there, but it's a lot more to get into. So I'm not going to get into that here. So, okay, just listening to what he's saying now, and then we'll get in. But before I do that, are you ready? Are you ready? Let's get it. All right. I had to give that intro. That's just what I regularly do. Anyway, all right, let's listen to what John Denton is doing. Let's get in. All right.
Everything is a security to them. And this is insane. Now, one of the things the judge did recognize, and this was one of the things that made me optimistic, is he recognized the importance of the industry. He said it's a big industry. He said there are a lot. The judge had to respect for entrepreneurship, for American innovation, and he said, "Hey, there are a lot of them."
And that's the point: respecting American innovation, really, really sincerely, because these other hypocrites, like Judge Nepburn said, don't. And we have to push that narrative. We have to put that out there and let the people be aware of the corruption. I don't care how much protests are going to the streets or whatever, or the people don't care about the system anymore. That's beyond. We're beyond that. We have to get to a position where we have to make this change and take control over our lives more than allowing them to take control over our lives as they've been doing with this traditional system that has been corrupted, as we come to know. Many of us don't know, but we need to know. And this is some of the process here. These guys are part of the process. Listen to what they're saying.
Americans who are building companies. There are a lot of people who believe in this. And so he does understand. I think the judge honestly doesn't like the fact that he has to rule on this case. I think he feels like he's in a really tough position because the judge is clearly, hesitant to set a precedent, right? He doesn't want to get overturned. And the SEC is coming and asking him to set a precedent one way or another. Because the judge has said, hey, he talked about this concept of mixed use, this idea that a number of people are using it for a consumptive purpose. And I will say, the SEC, they admitted in court, the SEC prosecutor said, yeah, a substantial amount of people are clearly buying the LBRY token to use it. Okay. So by the way, again.
Well, what did you think when that was brought up? And I wrote this down. The SEC attorney actually said to the judge, because the judge said, will you concede that some of these people, a lot of these acquirers of the LBC token are using it for consumption and not investment? And the SEC attorney agreed because he had to, but then he said, utility doesn't matter.
Utility doesn't matter. They're creating a new standard in real time here. Look, in my view, it's an open shut case. But here's the thing.
And what is that new standard? All part of the plan, new standard. That's what it is. And if we don't put our position against them as a full-fledged group of cryptocurrency holders, cryptocurrency developers, cryptocurrency utility, network creators, all of that in the whole space together against them. Lawyers now, you got crypto law. We have the infrastructure building up or has built itself up in the crypto space, but we're not using it together. We're using it in all these different parts and the parts away and this way and that way and going up against each other. I'm Bitcoin. I'm XRP Army. I'm Shibu Nu. I'm a Dogecoin person. I'm a this type of person. I'm a this type of army. Not to say, okay, you can have your groups, but don't be so tribal with it. Come together and get this thing done. Work together like these guys are doing. And they have no choice because they know that's what's needed. This is the point. But they're all coming after us. So you better be ready. Are you ready?
I have an incredibly low and pessimistic view of the American justice system, right? So the fact that I think it's an open and shut case, I don't know that means much, because we've seen the United States justice system output a number of cases that are, quite frankly, incomprehensible to anyone with a basic sense of logic. So, I don't, to me, actually,
I feel him. I'm feeling him like that because I haven't trusted him for years. And I'm especially not just being in the streets and the stuff and whatever happened to me, but I haven't trusted them for years. And being this color, that's a whole nother story.
Making a prediction, I would defer to you. I would defer to my attorneys because you guys model the courts. I think they're insane.
I will tell you this: your insight is on point about something, and I won't sugarcoat it. I left being more pessimistic than I was when I got there. Okay. And I picked up on, that doesn't mean I think that you're losing or anything, right? Because it was that judge's hesitation. And before I can make a prediction, I'm going to have to study that SG case. The judge basically said, and you tell me if I'm misspeaking, that he was going to strictly apply to the language and everything of that SG case from the First Circuit. And the feeling that I got, and you're on point, is saying the judge is hesitant. I think he's uncomfortable about this decision because he kept saying, he said at least 5 times, I need to know what standard, which you just said a few minutes ago, what language do I apply? When there is a mixed use case, when some of these people are using it and acquiring it just for use, and some are clearly for price appreciation and speculation, what do I use? What standard do I use? What language? He even said, what formula do you suggest I use, right? And I know that your attorney, LBRY, said you go with the principle kind of approach, and that if it's principally for use, then it clearly should not be a security. I'm dumbing it down, but that's in essence what I thought he said. You tell me.
But this is insane, right? But this is insane. But that's why he got to, well, if it's the principal standard, then 75, 25, 25, 75, how does it change? The judge then stated that would be an absurd standard because it wouldn't be a standard that could be determined.
Right.
I will say that all of this then, though, brings it back to fair notice because, which we didn't get into much in court today, but to me, look, I don't mean to be a cocky guy, but I'm a lot smarter than the average person. And this law is absolutely indecipherable. It's indecipherable how to apply these tests to these cases. The judge doesn't know how to apply the standard. Like, the judge is in court and clearly confused as to what the law says. Well, if the judge is confused to what the law says, a guy who studies it professionally, by what standard could an average person understand what the law says? I mean, that to me makes it open and shut again right there. If the idea that an average person is supposed to be able to understand the law and the judge is in court saying, I don't understand the law, well, then how could the average person understand the law, right? You would think that would be sufficient. Right. But no, the judge, and certainly one of my worries is he's going to say, well, you know what? The SEC knows the law. We ought to trust the regulators, because he is that kind of, conservative type.
So basically, I'm going to let that all go, and we're going to go on to listening to my man Jeremy Hogan. But you get a lot what they say in there, and their video, Crypto Law, John Denton's channel. Go and watch that video. Finish the video. Shout out to him. Shout out to Jeremy Kaufman for being on there, and then just giving his view and understanding and experience what he's going through in his organization, his company, with their project of the LBRY coin that they put together and developed, and what these people have been putting them through in the court case that they're in. Okay, so basically, let's get into what Jeremy is dealing with. Okay, hold on for a sec. Let me get it up. We can let him talk a little bit about what he's dealing with. Hold on, cue it up for a quick minute. I'm gonna cue past that. You can watch his video. Shout out to him. His video, as you seen that woman in there, was his mother. But you know, I just want to get to where he's talking about. Really. Oops, sorry. Okay. All right, so let's go.
And thank you, Mom, for chastising the SEC like only a mother could do. Quick family sharing. My mother went back to school in her 40s and obtained her master's degree, which just goes to show you how amazing she is, and also that it's never too late for you to change your life. Unless you're over 50, then it's too late. But speaking of late, so much has...
Yeah, I was just queuing it up to listening to him because the time that I have. But, you know, shout out to him, and you can go and watch the video and see what his mother said and what she did and what he had her to do for him, or I guess she helping him out there. But pretty much is dealing with the court case and what Judge Nepburn's, you know, recent order and her statement in relation to the SEC's shenanigans, as we could say, or what they've been doing. Okay, so listen to him about what's going on with that.
Has happened in the Ripple versus SEC case and in crypto news that I barely know where to start. So I will start at the beginning of where we left off. And in 12 to 15 minutes, maybe more, you will know everything that you need to know. Hang on to your hats. This will go fast. Tesla launch mode activated. So let's start at the first major order in the case, which is from about 10 days ago. And this is the Ripple versus SEC case. And it's about the ongoing Hinman email saga. As you know, for over a year and a half now, Ripple has been seeking discovery of the emails related to Hinman's 2018 speech, and they have still not received them. I've never seen a discrete discovery battle go on this long. Never.
And it's crazy for him to say he's never seen it. He's a lawyer. That if you think about it, what's going on in the law, you know, environment in that area where they're talking about these cases and dealing with these cases, the stuff that they're getting, like, what are these people doing? And what is the judges doing? Like Nepburn, even though she, you know, is making rulings and she's trying to she's not making rulings of what XRP is yet, and you know that hasn't been done because it's not to that point yet. They had to go through the discovery part of the litigation, and then first before that pre-discovery, then discovery, then now they're in this stage of the case, you know, where they're making, you know, their maneuvers and trying to get it to where they can close out, whether it's going to be a ruling on the side of XRP being a currency or not being a security. So, you know, in SEC's hand, like they want. Okay. So anyway, let's listen to more of what he's saying.
Judge Nepburn has ordered them to produce the documents on numerous occasions, and the SEC continues to file objection after objection, and the latest objection was maybe just one objection too far, because as we've talked about in like 6 videos now, the SEC continues to change the story on whether Hinman's speech was his personal opinion, an SEC opinion, or more recently, that it was his...
More than 50 plus experts in crypto.
We are not going to deal with that. So what I'm going to do is cue it up and just give me a quick minute to do that. All right, hold on. Hold on for a second.
Including a sitting U.S.
Cue that up, and you know, I apologize for that. All righty, ready? Let's get it.
Opinion. And listening to the hearing on the SEC's attorney-client privilege argument, which I did, I got a sense that the judge has just about heard enough. I mean, listen to this from the hearing. The judge, quote, "I hate to interrupt you, but you just said something that seems different to me. You said that the speech was given by Director Hinman in his capacity as Director of Corporate Finance. That seems different to me than what you said a year ago. Am I misremembering? Because when we were discussing whether he should be deposed, as I recall, there was argument from the SEC that what he said really had no bearing on this litigation because he wasn't speaking on behalf of that division, that he was really just speaking at a private event. And there was a lot of attention.
Playing games, playing around. That's what it is. I'm just putting it simple. As simply as put. They playing games, they playing maneuvers, they being underhanded, they being tricked, deceitful. That's what it is.
Focused on the disclaimers. But you just said just now that he was speaking as director on behalf of that division. Close quote. Now, keep in mind, this judge is extremely polite to the umpteenth percentage. So when she says, "I hate to interrupt you," she really doesn't hate it. She has to interrupt you because you are making a mistake. And when she says, "Am I misremembering?" she's really not asking. She knows exactly what you said. What the judge is doing is she is warning you that you are making a mistake and she's giving you an opportunity to fix it. Now, I caught this right away because I'm married and have learned something called warning cues. And it was that frustration and anger from the SEC's lack of logical candor to the court which led to this, the most scathing rebuke of the SEC to date by the court, and very uncharacteristic of this judge. Quote, "The hypocrisy in arguing to the court, on the one hand, that the speech is not relevant to the market's understanding of how or whether the SEC will regulate cryptocurrency, and on the other hand, that Hinman sought and obtained legal advice from SEC counsel in drafting his speech, suggests that the SEC is adopting its litigation positions to further its desired goal and not out of a faithful allegiance to the law." Close quote. Now, when I first read the order...
Now, the significance of that, and I'm not going to go much further with this, let you go ahead. You can watch the attorney Jeremy Hogan's, rest of his video, as well as John Denton's crypto law, their video. I'm telling you, the significance of what was said by Judge Nepburn needs to be drilled into you. You need to take heed to it. You people, us people, the armies, the Bitcoin maximalists, the Ethereum maximalists, all the cryptocurrency investors and businesses and produce, developers, what have you, have to take heed to this because this is significance. This case is a catalyst. It is what is the narrative of what is going on, crypto wars. Okay? That there's two sides, and the one side that doesn't want and wants to control continuously the financial transactions, maneuvering, and distribution of money, wealth in human beings' hands. It's here in America. Okay? And outside of America, you see what's been going on. The people against the crypto adoption, crypto innovation, crypto everything, anything, right? Digital currency. Then these countries are trying to create and compete with cryptocurrency and creating their own digital currency, CBDCs. We know this. Not to say that it's all bad, because with like cryptocurrencies like XRP, which is it has different features to it. ODL, on-demand liquidity, and the likes of these wonderful functions that can help to cross the bridges to where currencies can be interchanged and go be able to maneuver, and still liquidity can go through these different areas of finance. So that XRP has a place there, XLM has a place there, XDC has a place there. Even Bitcoin, on the level of when you're dealing with decentralized only, mainly because that's where it started from, and it's going to be there. There's a lot of people who are still dealing with Bitcoin, and even government has accepted, like El Salvador and these others that are coming and following behind. So we all in a good place, but at the same time we're in a tough place. We're in a battle place, and you have to be on the battlefield as yourself, being a person whether who's a pioneer or you're just a person just came in. You have to do your part because you may lose your part of this that you have invested in, or you may lose your right to use it, and it may make it where it's unlawful for usage, and like this, because they don't care. They don't care about us. They portray this facade, and they put it in their papers. They put it in their white paper for their organization, like the SEC, and you read about it and you hear him on the advertisement. What's his name? Gary the Goon Gensler in his advertisement, and he's up there, hey, and everything and you can do, and they bump all that crap. He's talking bull because he really isn't for you. Every time he gets to be questioned about his situation and what's going on with the SEC, why are they doing this? Why are they not doing this? And why is the regular retail investors suffering? You don't have no real good answers. He goes around the bush because that's their way. That's their technique. They got to do that, just like politicians. They avoid questions, questions in Congress. Congress is questioning the one of the directors over there in that oversight meeting, and you got one who's talking crap himself because he's part of the plan with them. He's just like Elizabeth Warren. He's just like this woman in the Treasury. All these people. So that's the warfare on both sides. That's on that side, and we're on this side. So what are you going to do? Are you ready? Well, anyway, don't forget to click the like button or punch it, pound it, whatever. And, do this for your brother. Do this for your crypto B-boy. And get me out there so that more people can hear, because I'm trying to cover these bases. I don't know. So some of us YouTubers, we're in other areas and we're more into other areas. So that's how it is. And, there's really not too much people who try to cover all bases in their videos, but there's some that do, like the DAI, the digital asset investor, Chiz Crypto, or different people out there. They're doing it. If I haven't mentioned any, forgive me. But some, they don't really cover some of this stuff. They get into more the technical part of the technology, or they get into more of the the basic investments or NFTs, or what companies or projects are coming aboard, and what to invest in, and the prospects to it. And then you have, like Bearable Bull, he deals with stuff like what I'm talking about, the case, and he deals with the conspiracies that people try to say conspiracy theories. No, we're not. We're past that. The conspiracies are factual now. They're getting there and they're being proven. The judge herself, Nepburn, hypocrisy. Is that not from conspiracy? Of being a hypocrite? You conniving behind it, showing the facade in front of the people, but then behind the closed doors, you're doing something else. That's conspiracy person right there to me. If you don't know, then you need to find out. But anyway, again, don't forget to subscribe if you already haven't, and share the videos. Click the like button. Until next time, Crypto B-Boy coming at you. Peace. Are you ready? Let's get it.